Hello and welcome to another episode on Business Regulatory Framework. This episode will sketch out the meaning and characteristics of the law of contract in Business Regulatory Framework. It will also outline the essential characteristics and contents of the Indian Contract Act 1872 and how a contract creates obligations. The episode will brief you about a contract by which one party promises to save the other from the loss caused to him by the conduct of the promiser himself or by the conduct of any other person, called a contract of indemnity. I am Amrita Ghoshkumar and the subject expert for this lesson is Dr. S. Miraj, who has specialized in human resource management and is currently teaching in Amity University. Today we will begin by discussing the Indian Contract Act 1872, which declares certain agreements to be void. Now, what are these agreements which are declared to be void? Agreements against public policy. The term public policy is not capable of being defined with any degree of precision because public policy in its nature is highly uncertain and fluctuating. 1. Trading with enemy. All contracts made with an alien or a foreigner enemy are illegal unless made with the permission of the government. An alien enemy is a person who owes allegiance to a government at war with India. Number 2, agreements for stifling prosecution. Contract for compounding or suppression of criminal charges for offences of a public nature are illegal and void. The law is you cannot make a trade of your felony or crime. You cannot convert crime into a source of profit. Number 3, contracts in the nature, champerty and maintenance. Maintenance means the promotion of litigation in which a person has no interest of his own. In other words, where a person agrees to maintain a suit in which he has no interest, the proceeding is known as maintenance. Thus, maintenance tends to encourage speculative litigation. Champerty is a bargain whereby one party is to assist another in recovering property and in turn share in the proceeds of the action. Number 4, agreements for the sale of public offices and titles. Profit by way of sale in public offices and appointments obviously leads to the prejudice of the public service by interfering with the selection of the best qualified persons. Such sales are therefore unlawful and void. Number 5, agreements in restraint of parental rights. According to the law, the father is the guardian of his minor child. After the father, the right of guardianship vests in the mother. This right cannot be bartered away by any agreement. Thus, the authority of a father cannot be alienated irrevocably and any agreement purporting to do so is void. Number 6, agreement in restraint of marriage. Every agreement in restraint of the marriage of any person other than a minor is void. Number 7, marriage brokerage or brokerage contracts. A marriage brokerage contract is one in which, in consideration of marriage, one or the other of the parties to it, or the parents or third parties receive a certain sum of money. Accordingly, dowry is a marriage brokerage and hence unlawful and void. Number 8, agreements in restraint of legal proceedings. A, by which any party thereto is restricted absolutely from enforcing his rights under or in respect of any contract by the usual legal proceedings in the ordinary tribunals, or which limits the time within which he may thus enforce his rights, or B, which extinguishes the rights of any party thereto or discharges any party thereto from any liability under or in respect of any contract on the expiry of a specified period, so as to restrict any party from enforcing his rights, is void to that extent. Number 9. Contracts interfering with course of justice. Any agreement for the purpose or to the effect of using improper influence of any kind with judges or officers of justice is void. Number 10. Contracts tending to create monopolies. Such agreements are void, being opposed to the public interest. Number 11. Agreements in restraint of trade. Courts do not allow any tendency to impose restrictions upon the liberty of an individual to carry on any business, profession or trade. Now let us look at wagering agreements. A wagering agreement is a promise to give money or money's worth upon the determination or ascertainment of an uncertain event. Thus, a wagering agreement is an agreement under which money or money's worth is payable by one person to another on the happening or non-happening of a future uncertain event. Now we will discuss the performance of contracts. Performance of contracts as per sections 37 to 67. A contract creates obligations. Performance of a contract means the carrying out of these obligations. Section 37 requires that the parties to a contract must either perform or offer to perform their respective promises, unless such performance is dispensed with or excused under the provisions of the Contract Act or of any other law. Who must perform? The promise may be performed by 1. The promiser himself as per section 40, or 2. By the agent, 3rd by the legal representative, and 4. Where, however, a contract involves personal skill or is founded on normal consideration, it comes to an end with the death of the promiser. Discharge of contract as per sections 73 to 75. The cases in which a contract is discharged may be classified as in A, by the performance or tender, B, by mutual consent, C, by subsequent impossibility, and D, by operation of law, and E, by breach. A, by performance. The obvious mode of discharge of a contract is by performance. That is where the parties have done whatever was contemplated under the contract. The contract comes to an end. For example, thus where A contracts to sell his car to B for rupees 85,000, as soon as the car is delivered to B and B pays the agreed price for it, the contract comes to an end by performance. B, by mutual consent as per section 62. If the parties to a contract agree to substitute a new contract for it, or to rescind it or alter it, the original contract is then discharged. A contract may terminate by mutual consent in many ways. 1. By novation. Novation means substitution of a new contract for the original one. The new contract may be substituted either between the same parties or between different parties. Number 2, by rescission. Rescission means cancellation of all or some of the terms of the contract. Where parties mutually decide to cancel the terms of the contract, the obligations of the parties thereunder terminate. Number 3, by alternation. If the parties mutually agree to change certain terms of the contract, it has the effect of terminating the original contract. There is, however, no change in the parties. Number 4, by remission as per section 63. Remission is the acceptance of a lesser sum than what was contracted for, or a lesser fulfillment of the promise made. Number 5, by waiver. Waiver means relinquishment or abandonment of a right. Where a party waives his rights under the contract, the other party is released of his obligations. Number 6, by merger. A contract is said to have been discharged by way of merger, where an inferior right possessed by a person coincides with the superior right of the same person. Number C, by subsequent impossibility as per section 56. Impossibility in a contract may either be inherent in the transaction, or it may be introduced later by the change of certain circumstances material to the contract. 1. Destruction of subject matter of the contract. 2. By the death or disablement of the parties. 3. Subsequent illegality. 4. Declaration of war. 5. Non-existence or non-occurrence of a particular state of things. As soon as either party commits a breach of the contract, the other party becomes entitled to a few reliefs. 1. Rescission of the contract. 2. Damages for the loss sustained or suffered. 3. A decree for specific performance. 4. An injunction. And 5. Suit on quantum meruit. 1. Rescission of the contract. When a breach of contract is committed by one party, the other party may sue to treat the contract as rescinded. In such a case, the aggrieved party is freed from all his obligations under the contract. Number 2, damages. Damages, generally speaking, are of 4 kinds. A. Ordinary damages. B. Special damages. C. Vindictive or punitive or exemplary damages. And D. Nominal damages. A. Ordinary damages, section 73. Ordinary damages are those which naturally arise in the usual course of things from such breach. The measure of ordinary damages is the difference between the contract price and the market price at the date of the breach. B. Special damages, section 73. Special damages are claimed in case of loss of profit, etc., when there are certain special or extraordinary circumstances present and their existence is communicated to the promisor. The non-performance of the promise entitles the promise to not only claim the ordinary damages, but also damages that may result therefrom. C. Vindictive damages. Vindictive damages are awarded with a view to punish the defendant and not solely with the idea of awarding compensation to the plaintiff. D. Nominal damages. Nominal damages are awarded in cases of breach of contract where there is only a technical violation of the legal right but no substantial loss is caused thereby. Number 3. Specific performance. Where damages are not an adequate remedy, the court may direct the party in breach to carry out his promise according to the terms of the contract. This is called specific performance of the contract. Number 4. Injunction. Injunction means an order of the court. where a party is in breach of a negative term of contract, that is, where he does something which he is promised not to do, the court may, by issuing an order, prohibit him from doing so. Number 5. Quantum meruit. The phrase quantum meruit means as much as is merited or earned. Special contracts like indemnity, guarantee, bailment and pledge. Agency are described as follows. Contract of indemnity as per section 24. A contract by which one party promises to save the other from the loss caused to him by the conduct of the promiser himself or by the conduct of any other person is called a contract of indemnity. The person who agrees to compensate the loss is called the indemnifier, and the person whose loss is to be made good is called indemnity holder. For example, A promises to indemnify B, a banker, for any loss that he may sustain by reason of the dishonesty of the cashier appointed by B at the request of B. The contract between A and B is a contract of indemnity. Here A is the indemnifier and B is the indemnity holder. Contract of guarantee, section 126. Contract of guarantee is a contract to perform the promise or to discharge the liability of a third person in case of his default. A contract of guarantee involves three parties. The person who gives the guarantee is called surety. The person in respect of whose default the guarantee is given is called the principal debtor. The person to whom the guarantee is given is called the creditor. For example, P gives a loan of rupees 10,000 to Q, and R promises to P that if Q does not repay the loan, R will do so. This is a contract of guarantee. Here Q is the principal debtor, R is the surety, and P is the creditor. In order to create a contract of guarantee, there must be a creditor, a principal debtor, and a surety. There must be a contract, first of all, between the principal debtor and creditor. Then there must be a contract between the surety and the creditor, by which the surety guarantees the debt. In addition to these two contracts, there must be a third contract by which the principal debtor expressly or impliedly requests the surety to act as surety. Creation of agency. An agency may arise in different ways. It need not be created expressly by any writing and may be inferred from the circumstances and the conduct of the parties. An agency can be created in some of these ways. 1. Agency by express agreements. 2. Agency by implication or an implied agency. A. Agency by estoppels. B. Agency by holding out. C. Agency by necessity. 3. Agency by ratification. Agency by express agreements. A contract of agency may be created by an express agreement. When a principal appoints an agent either by word spoken or written to represent an act for him, an express agency is created. Agency by implication. The relationship of principal and agents need not be expressly constituted and can arise by implication of the law as well. Authority to act as an agent can be inferred from the nature of business, the circumstances of the case, the conduct of the principal, etc. Thus, if a person realizes rent and gives it to the landlord, he impliedly acts for the landlord as an agent. Agency by estoppel. In many cases, an agency may be implied from the conduct of the parties, though no express authority has been given. Thus, where the principal knowingly permits a person to act in a certain business in his name or on his behalf, such an estoppel from denying the authority of the supposed agent to bind him. Agency by holding out, where a person permits another by a long course of conduct pledge his credit for certain purposes. He is bound by the act of such person in pledging his credit for similar purposes, though in some cases without the previous permission of his master. This is a case of agency by holding out. Agency by necessity. Sometimes extraordinary circumstances require that a person who is not really an agent should act as an agent of another. In such a case, though there might not have been an express or implied authority to do an act, the law implies such an authority in favor of that person on account of the necessity that had arisen. Agency by ratification or confirm. Ratification is an approval of a previous act or contract. It implies the adoption by the principal of an act made by an agent in his behalf, but without his authority. In case the principal adopts the act of the agent done without his authority, he is said to have ratified the act. On ratification, the act of the agent becomes the act of the principal, and he becomes bound by the same, whether it is for his loss or his advantage. Termination of agency. 1. By the act of parties. A. By agreement between the parties. B. By revocation of authority by the principal. C. By renunciation by the agent. Number 2. By operation of law. A. By completion of the business of agency. B. By the death or insanity of the principal or agent. C. By the efflux of time. D. By the insolvency of the principal. E. By the destruction of the subject matter. F. By subsequent event rendering the agency unlawful. And G. By dissolution of a company. Now let us look at bailment and pledge. Bailment. The term bailment is delivered from a French word baillir, which means to deliver. It denotes a contract resulting from delivery. Definition: as per section 148 of ICA, this defines bailment as the delivery of goods by one person to another for some purpose upon a contract that when the purpose is accomplished, the goods shall be returned back according to the directions of the person delivering them. The person who delivers the goods is called the bailer. The person to whom they are to be delivered is called the bailee. Delivery of goods to the bailee must be for some purpose. For an example, giving cloth to the tailor to make a dress, delivering a car for repair, delivering goods to a railway company for carriage from one place to another, etc. Essentials of bailment. Delivery of goods. Delivery of goods must be for some purpose. Contract. Return of goods. Delivery of goods. The first important feature of bailment is the delivery of goods from one person to another. Delivery involves change of possession from one person to another and not a change of ownership. Mere custody without possession does not create bailment. Thus, a servant having custody of the goods of his master or a guest using the goods of his host is not a bailee. For example, a lady employed a goldsmith for making ornaments out of old jewelry. Every evening she received the unfinished jewelry and put it into a box kept at the goldsmith's shop. She kept the key of that box with herself. One night the jewelry was stolen from the box. It was held that there was no bailment as the goldsmith had re-delivered to the lady the bailer. The jewelry bailed with him. delivery of goods must be for some purpose. Section 148 requires that there must not only be a delivery of goods, but the delivery must be for some purpose. Where some goods are delivered by mistake, there is no bailment. Delivery of goods being for a purpose, the bailee is bound to return the goods as soon as the purpose is achieved. Where a person takes a jewelry to wear it during a mela, he is only a bailee, as he is under an obligation to return the jewel after the function. Contract. Bailment is based upon a contract between the parties. The relationship of bailer and bailee is the creating of a contract. Since a minor cannot enter into a contract, he cannot be held liable as a bailee if he misuses the goods or incurs losses. However, he can be compelled to re-deliver the goods to the bailer if the goods are in his possession. Return of goods. Bailment of goods is always for some purpose and is subject to the condition that when the purpose is achieved, the goods will be returned to the bailer or disposed of according to his directions. If there is no contract to deliver back or otherwise to dispose of the goods according to directions, there is no bailment at all. A deposit of money with a banker is not a bailment, as he is not bound to return the same notes and the same coins. Let us quickly now summarize all that we have learned today. The Indian Contract Act 1872 declares certain agreements to be void. A contract creates obligations. Performance of a contract means the carrying out of these obligations. Section 37 requires that the parties to a contract must either perform or offer to perform their respective promises. Unless such performance is dispensed with or excused under the provisions of the Contract Act or provisions of any other law. As soon as either party commits a breach of the contract, the other party becomes entitled to many reliefs, like 1. Rescission of the contract, 2. Damages for the loss sustained or suffered, 3. A decree for specific performance, 4. An injunction, number 5. Suit on quantum merit, a contract by which one party promises to save the other from the loss caused to him by the conduct of the promiser himself or by the conduct of any other person, is called a contract of indemnity. The person who agrees to compensate the loss is called the indemnifier, and the person whose loss is to be made good is called the indemnity holder. Contract of guarantee is a contract to perform the promise or to discharge the liability of a third person in case of his default. The term bailment is derived from a French word baillir, which means to deliver. It denotes a contract resulting from delivery. That is all we have for you today. Hope you have understood the concept of the law of contract. We will see you soon with another topic on business regulatory framework. Till then, you take care and bye-bye.